Hello everyone, welcome to this session. I am Dr. Mayank Pratap, Assistant Professor, Faculty of Law from Banaras Hindu University. And we are dealing with a course that is Understanding Competition Law, Theory and Practice. So we are in Module 1, that is particularly we are dealing with first week, and this is the third lecture where we will have discussion with meaning of competition law, that means competition law, meaning and necessity. And the objective of this particular lecture of today to understand the meaning of competition law and to discuss the necessity of competition law and why competition act is needed. That means competition law, why competition law is required, and what is competition law and what is the justification behind the adopting of competition law. So with these key elements we will have discussion with today's lecture. So while keeping start with the today's lecture, just previous lecture, just have a glimpse what we have discussed already in lecture number 2, that means in previous lecture. If you remember, in last lecture we have dealt with the meaning of fair and unfair competition. In last lectures, what we have discussed already, the meaning of competition, what is competition and what are the ways to competition, where we have already discussed that competition is generally the fight or the rivalry between the two rivals or more than two rivals for achieving or for striving achieving for some common goals. That means where they have to just for the sake of showing their superiority or achieving someone. So the important thing is how and what practices they adopted in that competition. And what we have already discussed in last lecture, that there are two ways or probably there are the two types of the formula what they adopted. Sometimes this is malified and sometimes this is the fair and a good way, which is known as fair and unfair competition. So in previous lecture we have discussed the meaning of fair and unfair competition, where we have discussed with the meaning of fair that fair competition is essential for promoting innovation, efficiency and consumer choice for preventing harm to the economy and society as a whole. That means fair competition is just like the fair formula or ethical formula adopted by the firm or companies or entity to expand their business or to invite or attract the customer towards their promotion, towards their business, towards their product or services. And this is the essential part for the purpose of beneficiary of the consumer. But on the other hand, when the entities or firm or the companies or the people who are in rivalry adopt the unethical formula, which is known as unfair competition, so that unfair competition you can say, which refers to the business practices that violate the principle of fair competition, where companies use deceptive, fraudulent or unethical means to gain an advantage over their competition. So this leads, and this may include the deceptive prices, misappropriation of trade practices, trademark infringement, false advertising, so that the competition may be by the way of fair competition, by the way of unfair competition. Fair competition is healthy competition which is in prescribed manner and which is good for business, for economy, from the perspective of market and from the perspective of the ultimate beneficiary, that is consumer, and that must be promoted. And on the other hand, the unfair competition, which is the practice or formula which is adopted as unfair mean or malified intention or just for the sake of unethical mean to spend their business, must be prohibited, must be suppressed. And for that purpose there are some key legislation. There are generally two legislation which regulate these type of practices. First, which is Consumer Protection Act, and second is Competition Act. We are here in this particular session, and this particular course is generally will cover and will see the Consumer Protection Act as only a tool to the consumer, and which is not the part of our course, we will discuss the Competition Act and the understanding of Competition Act and what are the studies, what are the formula and what are the objective for adopting the policy and law, aim and object under Competition Act. But these why we are going with the some terms like the Consumer Protection Act, whatever they are, two key legislation, but ultimate goal is same, just to provide the beneficiary, that is consumer, the welfare of consumer, so that on such platform, on some note, the welfareness of consumer, they are at equal footage. But yes, the Competition Act, what we'll have to deal with is ultimate and the separate object, that just not to only the welfare, but just to promote competition and to encourage efficiency, economy and to regulate the anti-competitive practices. So with this, we'll start with the meaning of competition law. What is competition law? Competition law, sometimes it is also known as antitrust law. That means it is a body of law, regulation designated to promote fair competition and prevent anti-competitive practices in the marketplace. The primary objective of competition law is to ensure that businesses compete with each other on level playing field without engaging in practice that harms or stifles innovation. If you see the meaning, what we have already discussed, what I am saying, competition law, which is also known as antitrust law. What is antitrust? Whether antitrust and competition are the same. If you see the term antitrust term comes from the UK. That means the United States school. The antitrust comes from basically from an idea, that is of being against trust, which were large corporations that dominated industries and stifled competition. Antitrust law aimed to prevent the formation of such trust and to promote competition. If you see the example of antitrust law, that is Sherman Act of US, Clayton Act of US, and yes, of course, the Competition Act 2002 of India. So what is competition law basically? Competition law basically an statute or act which prohibits agreement or action that restrict competition. That means basically the act or law which deal with prohibition of anti-competitive practices, whatever such as cartels, monopolies or abuse of dominant of force. It also regulate merger and acquisition to prevent the creation of entity that could harm competition. So that generally what you can say, competition law is a law which is for the purpose to promote competition as well as to restrict or prohibit the anti-competitive practices, and yes, well, to advocacy, that means to competition advocacy, to regulate the you can say the dominant position, abuse of dominant position, and to regulate the merger and acquisition to prevent the creation of entities that could harm competition. The definition of competition law, of course, this is not a such term which can be used as a definition, so that in the bare provision there is no terms like the competition law which is used for the purpose of definition. But yes, for the purpose of the definition and academic term, we can refer some jurists like the Richard Wyss and David Bailey, as well as Philip Edrit and Herbert Harker. So if you see the competition law definition, what is given by Mr. Richard Wyss and David Bailey, competition law is a law which prohibit agreement and concert practice which restrict competitions and which prohibits abuse of dominant position and which regulate concentration of undertaking. So this was the definition given by Richard Wyss in 2018, and again by Arida and Hockham, definition is given under that means in year 2006, and the definition is not basically with the term of competition law, what they use the term, that is antitrust law, because both the term which can be used synonymously. So we can say antitrust law or competition law is the law of competition. The law regulates competition among firms to produce goods and services. So, if you see the definition of competition law in a general perspective, or the meaning and definition of competition law what is given by some jurists, you can summarize it as competition law is a law which is basically the sets of rules that govern and behavior of businessmen in marketplace with the aimed to promoting competition, innovation and consumer welfare. It prohibits anti-competitive practices such as cartel, monopolies and abuse of dominant position, and it regulates the merger and acquisition to prevent harm to competition. So, the competition law is basically the law which is for the purpose and with the objective to promote competition, and it is a law or set of law and rules which is for the purpose to prohibit anti-competitive practices, to prohibit the abuse of dominant position of entities, to regulate the merger and acquisition activities of the different entities, that means to regulate the combination from the firm, and any entities activity including cartel, price fixing or anything of the anti-competitive agreement or agreement which comes within the meaning of anti-competitive agreement or such dealing which is basically to prevent to harm to competition. So, with this, competition law in general consists the provision with respect to 2 or 3 things. If we see, the competition law is basically a rule, a set of rule or regulation, and morphologically or anatomically, if you say the what would be the structure of a competition law, in competition laws naturally there are 2 or 3 things which must be there, like to regulate the behavior and structure of firm in market. The other aspect or fold of the competition law, this is like the institutional and enforcement design, and again competition advocacy. So that if you see any antitrust law or competition law, whatever the Sherman Act, Clayton Act of USA or the India's Company Act, there are 2 or 3 basic approach which include some other wing or edges, just like the behavior and structure of firm. What is the meaning of behavior and structure firm? Actually, the competition law or the set of rules regulate the behavior and structure of firm in forms by including the provision which restrict or prohibit the anti-competitive agreement, which prohibit the abuse of dominant, which regulate the merger and acquisition. So, these type of the provision, with the inclusion of this type of the provision, the ultimately competition law regulate the behavior and structure of firm. On the second fold, the competition law is basically to enforce the design and the institutional mechanism, just like to inclusion of the provision like composition and structure of competitive authority, selection in terms of condition of the member of competitive authority. That means for the purpose of enforcement, the second edge or the second objective of competition law to include the provision for the purpose to enforce the object. And how to enforce the object? By insertion of some enforcement method or institutional method which may regulate the things, what is for what purpose the behavior and structure firms are there. So that just like the inclusion of competitive authority or any competitive authority or competition authority for to take the object. And the third structure or fold you can see in any competition law, competition advocacy. Competition advocacy is important. Competition advocacy is not only the important aspect of antitrust law or competition law for the purpose to regulate. It is not basically to regulate the firm. It is not basically to regulate the behavior or enforcement. Yes, it is important for the purpose of public analysis, to gather the comment and recommendation by the competition authority with respect to anti-competitive effect and existing the further. That means it is important to improvement in the provisions what we have already existence, and where we are getting failure, where we are at the back step or back foot, they by the inclusion of this competition advocacy, the law regulation rules may be promoted effectively with amendments and with some other aspect, so that existing future policies for making of law regulation with that perspective and other action of the government and all may be covered within the meaning of competition advocacy, so that a good competition law or antitrust law having three wing or three A's. First, to you can say for the purpose to regulate the behavior and structure of firm, which includes anti-competitive agreement, abuse of dominance and merger of acquisition. The second fold is for the purpose of institutional and enforcement, which include the competitive authority and mechanism and rules and the enforcement and the that means the procedure how to get the mechanism to evolve the mechanism to enforce the objective, and the third is competition advocacy. So, there are two terms what we have already discussed. If you remember in lecture 1, we have gone through with the word competition policy, and now in this lecture what we are discussing the meaning of competition law. So, is the problem what is the competition law and competition policy, whether these are both are the same or whether there is any difference, or if both are the same or both are the difference, we are using the two terms, is there any relation? So, with this what we can see the competition law and competition policy in terms of relation and differences. Basically, the competition law and policies are closely meet with each other, that is related to each other and related concept that work together to promote fair competition and to prevent anti-competitive practices in marketplace. Actually, what competition law, what we have already discussed in this lecture, competition law is basically which refers to the law, rules and regulation that governs competition in a particular jurisdiction, and these laws prohibit particularly the any anti-competitive law, and if you think in context of this, that means the competition law 2002, the Indian Act, it is for the purpose of to prohibit anti-competitive practices, competition policies and to regulate the merger and acquisition. What you can say, this is a set of rule, law and regulation to promote competition, that is in fair manner, to regulate the merger, to prohibit the anti-competitive practices and to prohibit the dominance of any, abusing dominance of any firm. And again, on the other hand, what is policy? We have already discussed the general meaning of policy, which is that means the policy adopted by the government or lawmaker. Competition policy basically provide the framework of competition law, which outline in objective, principle and guideline for promoting competition and preventing anti-competition practices. So, in same manner, what you can say, actually competition policy is a wider term with comparison to competition law. Competition law is a set particular which applies in a particular jurisdiction with particular object. Rather, competition policy is a policy which actually which actually framed the outline where competition law have to work. That means to execute the guideline of competition law, the competition policy, competition law may be used as a tool. So, in the front term, if you see the scope, the competition law focuses on a specific law and regulation like Competition Act 2002, while competition policy encompasses the broader principle and guideline. If you see in the terms of objective, competition law aims to enforce specific rule and regulations, while competition policy aims to promote overall competition and consumer welfare. In terms of enforcement, competition law is enforced through a specific law and regulation, while competition policy is enforced through a combination of laws, regulation and institutional mechanism. So that in interlinked term, the competition law and competition policy, if you see the differences, if you see the interlink, competition policy is essentially understood to refer to those government measures that directly affect the behavior of firm and the structure of the industry. A consistent and realistic competition policy includes both. That means in a competition policy, there is not only the economic policy, but economic policy with the competition law. If you see the twofold of competition policy, it includes the economic policies adopted by the particular government and as well as the tools in the measure in the form of law and statutes. That means competition policy includes economic policies that is adopted by government, which for the purpose to enhance competition in local and national market. For the sake of example, such as policy of the economic deregulation and privatization, like. And the second aspect is competition law. Competition law is basically designed to stop competitive business practices by firm and unnecessary government intervention in the market. So that therefore you can say competition law is wider in range, which include competition law. So that you can say competition policy means what? Competition policy is basically the economic policy that affect competition plus competition law. That means competition law is sub-term under the competition policy. In India, if you see the relationship between competition law and policy, competition law in India is known as the statute, the Competition Act 2002, which is the primary legislation governing competition in India, which is for the purpose to prohibit anti-competitive agreement and abuse of dominant position, which regulates merger and acquisition, which is for the purpose to establish the Competition Commission of India as a regulatory authority. And on the other hand, competition policy in India, if you see, the competition policy in India is outlined in the National Competition Policies 2011, which with the aims to promote competition and consumer welfare. It actually encourages fair competition and prevent anti-competitive practices. It is for foster economic growth and development. So that the Competition Act 2002 and the National Competition Policy 2011 are interconnected, and the Act provides the legal framework for enforcing competition law, while the policy outlines the broader object of principle for promoting competition. So there is a difference between competition law and competition policy. In general meaning, in a formula based, what you can summarizedly you can say that competition policy is basically the outline, the guideline, the formula or the principle adopted by the concerning government as per their economy, as per their market, as per their policy, and which include the general principle on which they have to work on their economic perspective. And competition law is generally the sub-term under the competition policy, which can be used to the you can sharpen for the edge of the competition policy or adopted principle under the competition policy. So competition policy includes economic policies of the nation as well as a statute like the competition law or competition act. So again, why competition law? Because the only competition law is required. It is not such a way. Why competition law is important is a very important term. If you can see with this illustration, X is a starting furniture business. For sake of simplicity, it is assumed that he can source raw material, make the furniture and sell them. If A is only person selling furniture, then he can control the price and quality of furniture. He will also be able to control the cost of production as no one else in the market in buying the raw materials. And second, now let us consider the second scenario where there are multiple business selling furniture, Mr. X, Mr. Y, Mr. Z and are sellers. Each one can source the raw materials, make the furniture and sell them independently. Now all three of them must compete to create a better product to sell for furniture. Suppose in two scenario, just to think about in scenario number 1, X become a monopoly and has full control over the market. He can sell his product at unreasonable high price and consumer at disadvantage because there is no other seller. So that in this illustration, if you see the para 1, that means the scenario 1, there is only one seller, that is Mr. X, and in that case S become monopoly and there is a danger about the situation where he can sell the product at unreasonable high price. But in the second scenario, where we have seen that there are more than 2 or 3 seller like Mr. X, Y and Z, the situation is, or this scenario is advantageous from the perspective of consumer. It is advantageous to the consumer as businesses are pushed to give a lower price and to improve the quality. This competition will also motivate them to improve or create a better range of product. The customer can choose between 3 different products and different options as well. So, by this illustration, one can understand why competition law is important, because competition law promote competition and restrict or prohibit anti-competition. And the Competition Commission of India in the case versus Steel Authority of India in September 2010, the Supreme Court advocates that with the observation that the advantage of perfect competition has threefold. It is for the purpose of allocative efficiency, which ensure the effective allocation of resources, for the productive efficacy, which ensure the cost of production and kept at minimum, and dynamic efficiency, which promote the innovative practices. So these factors have been accepted all over the world, the guiding principle, so that currently right now globally at least 129 countries have implemented the competition law. So in a summary, we can say the competition law is justified and necessary to promote the fair competition and innovation for the purpose of protect consumer welfare and prevent anti-competitive practices, foster economic growth and interpret. So with this, I am again leaving with a problem with you. You have to think upon it, and the problem is the government of a country is considering introducing a new regulation to promote a competition in the e-commerce sector, and the proposed regulation would prohibit e-commerce platform from giving preferential treatment to their own product on services, and with the second condition, impose a cap on commission fees that e-commerce platform can charge to seller. So again, the problem is the government of country is considering the introduction of a regulation having 2 conditions, and with the 2 conditions, you have to think over it whether it is competition law or competition policy. So you have to think over the problem and decide with this illustration what you think, whether it comes within the meaning of competition law and competition policy. So with this problem, I am leaving it with you, and we will again meet in next lecture with the nature of competition law in India. So that, thank you for today. Thank you very much.